Contract law forms the foundation of business relationships and transactions in the United Kingdom, providing the framework for enforceable agreements that drive the economy. This comprehensive exploration examines the principles, practices, and precedents that shape modern contract law, offering insights for legal professionals, business leaders, and students alike. From formation to enforcement, we'll navigate the intricate landscape of contractual relationships, highlighting key cases and statutory developments that continue to influence legal practice today. The UK's contract law framework combines centuries of common law development with modern statutory interventions, creating a robust system that balances freedom of contract with necessary protections. An estimated 92% of business transactions are governed by contracts, representing approximately £1.2 trillion in contract value annually within the UK economy. Modern contract law traces its origins to the 1677 Statute of Frauds, evolving through centuries of case law and legislative reform to address changing commercial realities. Contracts create enforceable rights and obligations between parties, providing remedies when agreements are broken. By establishing clear terms for business relationships, contracts facilitate commerce and provide predictability in transactions. With 70% of commercial disputes involving contract issues, well-drafted agreements serve as vital reference points when conflicts arise. Contracts also distribute responsibilities and liabilities between parties, allowing for strategic management of business risks. The UK's common law system means judicial precedent plays a crucial role in contract law development. Key legislation includes the Consumer Rights Act 2015 and the Sale of Goods Act, which codify important principles. Despite Brexit, European influences remain through the incorporation of CISG principles into UK practice. International standards, particularly the UN Adroit principles, increasingly influence cross-border commercial contracts, reflecting the globalised nature of modern business transactions. Each element must be present for a contract to be legally enforceable. Offer and acceptance involve a clear proposal and unequivocal agreement. Consideration is something of value exchanged between parties, while legal intention is the purpose to create binding legal relations. Legality ensures the contract's lawful purpose and terms, and capacity refers to the legal ability to enter contractual relations. The absence of any single element can render an agreement unenforceable, regardless of the parties' intentions or the formality of documentation. An offer is a definite promise to be bound by specific terms if accepted. It must be distinguished from mere invitations to negotiate or enter into a contract. The famous case, Carlyle Fiv Carbolic Smokeball Co., set a precedent on when an advertisement constitutes an offer rather than an invitation to treat. The original advertisement led to a legal case, promising £100 reward to anyone who contracted influenza after using the smokeball as directed. Understanding these kinds of critical judicial decisions helps clarify the nature of offers and invitations in contract law. Acceptance must be clearly communicated to the offerer, typically using the same medium as the offer or a method contemplated by the parties. The postal rule exception, established in Adams v. Linsell, 1818, states that acceptance by post takes effect when the letter is properly posted, not when received, a significant exception to the general rule. The 2000 e-commerce regulations address digital communications, greatly treating electronic acceptances as valid from the point of being accessed by the recipient. Silence cannot constitute acceptance, protecting parties from having obligations forced upon them without agreement. Consideration must involve something of value. Though courts don't generally assess adequacy, merely requiring sufficient value to constitute a bargain. The past consideration rule, established in Roscola v. Thomas, 1842, states that something already done before a promise is made cannot serve as consideration for that promise. Williams v. Roffibros, 1991, established that conferring a practical benefit can constitute consideration even when performing an existing contractual duty. Contemporary courts increasingly focus on the intention of parties rather than rigid formalities when assessing consideration requirements. The law presumes that commercial agreements are intended to create legal relations, while social and domestic arrangements typically are not. However, these presumptions can be rebutted by evidence to the contrary. The exception in Rose and Frank v. Crompton found that even commercial arrangements can avoid legal enforcement when explicitly stated as honour clauses. Modern courts take a more contextual approach to domestic agreements, recognizing that family members sometimes intend legal consequences. Minors, typically under 18, have limited capacity to enter binding contracts, though some exceptions are enforceable. Employment and education contracts may be valid upon reaching majority. Mental capacity, as defined by the Mental Capacity Act 2005, provides protections if a person is unable to understand the nature of a transaction. Corporate capacity is governed by the Companies Act 2006, which abolished ultra vires doctrine, allowing third parties protected even if transaction outside companies' objects. Directors may face internal liability for breach of authority, while agency principles determine whether company bound. Contract terms are classified according to their importance. Express terms are fundamental terms which, if breached, entitle the innocent party to terminate the contract and claim damages. Warranties are less important terms where breach only allows damages claims. Innominate terms, following Hong Kong Fur Shipping v. Kawasaki, are classified based on the effect of the breach rather than predetermined status. Exclusion clauses limit liability or obligations, often requiring specific incorporation through signature, reasonable notice, or course of dealing between parties. The Sale of Goods Act, 1979, implies terms regarding fitness for purpose and correspondence with description in contracts for goods. Similar protections exist in the Supply of Goods and Services Act 1982 for service contracts, implying reasonable care and skill. The common law test for business efficacy, the Moorcock, implies terms that are obvious, clear, and necessary to give the contract commercial coherence. Courts are increasingly reluctant to employ terms that would not be reasonable, focusing instead on what is necessary for the contract to function as intended by the parties. The unfair contract terms. Act 1977 prohibits exclusion of liability for death or personal injury caused by negligence and requires other exclusions to satisfy a reasonableness test. This test considers bargaining power, incentives for compliance, and whether the exclusion was transparent. The Consumer Rights Act 2015 provides additional protections in business-to-consumer contracts, applying a fairness test to all non-core terms. Exclusions must be transparent and prominent to be enforceable against consumers, with significant penalties for businesses using unfair terms. The Electronic Communications Act 2000 established the legal foundation for electronic signatures in the UK, recognising their validity for most commercial transactions. Courts increasingly accept various forms of electronic assent, from typed names to sophisticated encrypted signatures, due to their demonstrated authenticating intent. Click wrap agreements, requiring active clicks to accept terms, generally satisfy notice requirements, while browse wrap agreements, merely posting terms online, face greater enforceability challenges. Smart contracts utilising blockchain technology raise novel legal questions about automation, timing, and remedies when execution deviates from parties' expectations. Both parties may make the same mistake about a fundamental fact, known as a common mistake. Two classic categories are res extincta, where the contract concerns something that no longer exists, and res sua, where the buyer unknowingly already owns what they're purchasing. Mutual mistakes occur when parties are at cross purposes, misunderstanding each other about fundamental terms. Unilateral mistakes arise when one party is mistaken and the other knows or should know about the mistake. Most influential in cases of mistake identity or price, potentially voiding the contract if the mistake is material. Misrepresentation begins with an untrue factual statement, not opinion or intention, that induces contract formation. Courts determine whether misrepresentation was fraudulent, knowingly false, negligent, careless, or innocent, believed true with reasonable grounds. Rescission allows the victim to unwind the contract and restore pre-contractual position, while damages provide financial compensation under the Misrepresentation Act, 1967, with burden of proof reversed for negligent misrepresentation. Economic duress involves illegitimate pressure through economic threats, with no reasonable alternative for the victim. Universe Tankships case established that must coerce victims' consent to meet test. Actual undue influence involves direct improper pressure exerted, overpowering victims' independent judgment. Presumed undue influence arises from relationships of trust and confidence, such as doctor-patient or solicitor-client, requiring stronger party to disprove, Royal Bank of Scotland Fairfetridge established safeguards against undue influence. The fundamental doctrine that, from a dishonourable cause an action does not arise, prevents enforcement of illegal contracts. Courts refuse to assist parties seeking to benefit from their own wrongdoing, regardless of unfairness in individual cases. Statutory illegality prohibits contracts by statute, distinguishing between express prohibitions and regulatory requirements. The impact varies based on statutory purpose, importance of the provision, and proportionality of denying enforcement. Common law illegality relates to public policy, including those prejudicial to administration of justice, payment contingent on testimony, promoting sexual immorality, and those involving corrupt public practices. Performance must be complete and exact, though the doctrine of substantial performance allows recovery minus damages for minor defects. Parties may agree to discharge obligations through accord and satisfaction, waiver, or novation transferring rights to a third party. Breach must be repudiatory, going to the root of the contract, to justify termination, whereas minor breaches only permit damages claims. The innocent party must elect whether to terminate or affirm the contract within a reasonable timeframe after breach occurs. The frustration doctrine, established in Taylor v. Caldwell, applies when an unforeseen event makes contract performance impossible or transforms the obligation into something radically different. While courts do not easily accept frustration claims, as demonstrated in the Superservant II case, where a party's choice between alternative performance methods prevented frustration. The law reform, Frustrated Contracts. Act 1943 provides a statutory framework for distributing losses when frustration occurs, allowing recovery of expenses paid or benefits conferred. Courts assess claims often contractually allocate risk of supervening events, typically addressing the frustration doctrine. A breach of contract occurs when one party fails to fulfill their contractual obligations, leading to potential remedies for the innocent party. There are different types of breaches, including actual, anticipatory, and material breaches, each with specific implications and remedies. Understanding these distinctions is crucial for navigating contract disputes effectively. When a breach occurs, damages serve as a remedy to compensate the innocent party. Expectation damages are the most common, aiming to put the party in the position they would have been in had the contract been performed. Other types include reliance, nominal, and restitutionary damages, each addressing different aspects of loss and compensation. Equitable relief offers alternative remedies beyond monetary damages. Specific performance compels the actual performance of contractual obligations, while injunctions prohibit certain actions. Equitable considerations balance justice when granting relief, ensuring fairness in unique situations where monetary compensation is inadequate. Privity of contract refers to the relationship between parties in a contract, traditionally limiting enforcement to those directly involved. However, exceptions and reforms have evolved, allowing third parties certain rights under specific circumstances. Understanding privity is essential for determining who can enforce contract terms. Consumer protection laws safeguard buyers in transactions, ensuring fair treatment and quality standards. The Consumer Rights Act 2015 in the UK provides clear guidelines for goods and services, including rights to reject faulty products. These laws are crucial for maintaining trust and fairness in consumer transactions. Commercial contracts emphasize freedom and certainty, allowing parties to protect their interests through sophisticated agreements. Interpretation principles help resolve ambiguities, while boilerplate provisions streamline contract terms. Good faith obligations ensure fairness and honesty in commercial dealings, fostering trust and cooperation. International contracts involve complex considerations, including governing law selection and jurisdiction clauses. Post-Brexit, UK regulations continue to influence contract approaches, with international frameworks like the Vienna Convention providing standardization. These elements are vital for managing cross-border transactions effectively. Alternative dispute resolution offers various methods for resolving contract disputes, including mediation, arbitration, and litigation. Each method has its own success rates and costs, providing options for parties seeking efficient and effective resolution. Understanding these methods helps parties choose the best approach for their situation. Contract law is evolving with new developments such as smart contracts, good faith evolution, and post-pandemic clauses. These changes address modern challenges and opportunities, ensuring contracts remain relevant and effective in today's dynamic environment. Staying informed about these developments is crucial for adapting to new legal landscapes. The conclusion highlights the ongoing transformation in contract law, driven by digital advancements and changing societal needs. Balancing traditional doctrines with modern innovations is key to navigating this evolving field. Practical implications and further resources provide guidance for understanding and applying contract law effectively in various contexts.